Hello, this is Matt on the Moon Lambo channel. Ripple's legal team has absolutely destroyed and shredded the latest SEC legal argument, which is complete and utter nonsense. Just the other day, I put out a video where I was highlighting what the SEC was arguing. They brought up a case, an completely unrelated case. SEC versus Keener is the name of that case, in which the judge ultimately found, I think it was summary judgment anyway. Yeah, it was summary judgment. The judge found that the defendant in that case did have fair notice, and so, as a result of the outcome of that case, that should be looked at basically as precedent, indicating that Ripple should not be able to move forward with their fair notice defense. And so I highlighted why I thought that was complete and utter nonsense in a video, and I'm not going to rehash all of those reasons. All of this is new information that I'm covering in this latest Moon Lambo Hot Jam. But Ripple responded after I made that video and shared why they think it's nonsense. And also, XRP community members and attorneys Jeremy Hogan and John Deaton both shared their thoughts on this, and I'm going to highlight that in this video as well. So I'll explain exactly what's going on here. But I do want to be clear at the outset, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So yesterday, and this is what I highlighted video yesterday, and I don't feel like I really need to do an additional recap on that. I think in the outset of the video I pretty well explained all you need to know to move forward here. But did want to give credit again where it's due. James K. Filan, he is the attorney within the XRP community who shared this document, and he also shared after that Ripple's response to that document. So anyway, credit where it's due. And so in response to the first document, not the one that Ripple responded to, not Ripple's response rather, the document where the SEC was arguing that this SEC versus Keener case supplemental evidence to indicate, hey, it doesn't make sense for Ripple to be able to move forward with their fair notice defense. Well, here's what attorney Jeremy Hogan had to say about that. The SEC is not winning these cases at the motion to strike stage where the Ripple case is at, but later in the litigation at motions for summary judgment. The fair notice defense depends on the specific facts of each case and will be decided at summary judgment and not at a motion to strike, in my opinion. And I will, if you don't know what that means, what he's talking about specifically, I'm going to thoroughly break that down in as much detail as I possibly can. And actually, you know what? I think I could do that at this point in the video. That's probably a sufficient point to go ahead and jump in. Now, what I'm going to do is, this is Ripple's response. I'm not going to read it. It's on your screen. It's technically 2 pages, but the second page, here's the second page. It's just a signature line, so I'm going to keep it on the first page. So I don't feel the need to read through this. I want to explain what's going on here, but if you do want to read the actual document, just hit pause, and you can see it for yourself right here. But look, the court case that the SEC referenced in its legal filing yesterday, which again is SEC versus Keener, is not remotely similar to the SEC versus Ripple case. In SEC versus Keener, which the SEC seeks to use as precedent to shut down Ripple's fair notice defense, what actually happened is that the fair notice defense was considered in that case. It was considered. However, upon summary judgment, which is the judge's final ruling in the case, it was found that there was no lack of fair notice. This is substantially different than what's going on in the SEC case against Ripple. Now, right now, we're waiting for Judge Torres to rule on whether or not Ripple can even have their fair notice, defense considered in the case. So, if Ripple is allowed to proceed with arguments pertaining to their fair notice defense, then at summary judgment, which again is the judge's final ruling in the case, a determination will be made as to whether or not Ripple actually had fair notice from the SEC that what they were doing was in fact illegal, right? So to be clear, the final determination of whether or not Ripple had fair notice from the SEC is a different question than whether or not Ripple should even be able to argue in court that they didn't have fair notice from the SEC, okay? So the SEC is saying, yes, In the SEC versus Keener case, the defendant was allowed to argue that they didn't have fair notice, but since the final determination at summary judgment was that the defendant did have fair notice, Ripple should not even have the opportunity to argue that they didn't have fair notice, even though Keener did have the opportunity to argue that point. This is insanely illogical and asshattish. Extremely illogical and asshattish. And look, the SEC is absolutely aware of this, but this is another example of them making arguments that they couldn't possibly believe, and they're just hoping the judge will fall for it. And we see this again and again and again in this case. It defies logic and reason. Think about it. Think about it. Let's say these two cases were occurring simultaneously, SEC versus Keener and SEC versus Ripple. You get to the point where the judges are ruling should in each case, should the defendants in each case, and these are completely unrelated cases, should the defendants in each case be able to proceed and argue, even just argue, whether or not there was fair notice. So that would be the fair notice defense. Should they even be able to argue? And let's say that the answer was yes for both of them. And for SEC versus Keener, the answer was yes. And then imagine that one of those cases completes sooner than the other. And let's say it's found, and in this case it was found with SEC versus Keener, that they did have fair notice. Now Ripple should no longer be able to argue that they did not have fair notice just because a conclusion for a separate case, unrelated completely, found that with those specific facts and circumstances that there actually was sufficient fair notice. It's just you want to bash your head against the wall just reading this nonsense. It's complete and utter garbage. It's complete trash. But this is what the SEC is putting out there. I don't see how the judge can fall for this. Because look, I don't have a legal background of any kind, but I have more than half a brain, and I know that this doesn't make logical sense. It simply, absolutely, unquestionably does not make any damn sense. What a bunch of asshats. And so that the point that I covered from Jeremy Hogan, that's effectively what he was getting across here. And then so when he wrote that, by the way, that was before Ripple's response, what I just shared with you. Then Ripple shared their response, which I didn't read, but was on your screen for a long time there. Jeremy Hogan then retweeted that response from Ripple, and he referenced what one of Ripple's attorneys, Michael Kellogg, had to say. He referenced it here, and he wrote, "When me and attorney Kellogg see the exact same thing, he just says it much better, you know it's got to be right." So that's the point that I was getting across in this video. That's what was highlighted in this. It's that they're at completely different stages in the judicial process. Okay, so you're talking about summary judgment at the end. That's the SEC versus Keener case. And then with the Ripple case, we're not there yet. We're at the motion to strike phase. And the judge hasn't made a determination one way or another. We're not at summary judgment. It's not the same thing. Apples and oranges, my friends. And so then there is an individual that wrote to James K. Filan after he shared the Ripple response there. And this guy named Henry tagged attorney Jeremy Hogan and attorney John Deaton and wrote, "Is it normal that they replied so fast?" And the reason he's saying that is because it didn't take long for Ripple to respond after the SEC put out this complete and utter nonsense. It's honestly the quickest response from Ripple in response to any SEC document that I've seen in this case. So it caught my attention as well. And so then Henry wrote, "Is the ruling coming soon and they know it, or they knew what SEC will submit today? Is it me, or is it a little strange about this lightning fast response?" And John Deaton responded to that, and he wrote, "It didn't take long because the case cited by the SEC is slightly above meaningless at this point. If anything, it shows how scared the SEC is of the fair notice defense. If it was a decision from the Second Circuit, it would be a big deal. It's like comparing an apple to an orange, pun intended." And I do like that. Comparing an apple to an orange, referencing, of course, the orange groves and oranges in the Howie case. Because we all know that oranges, simply by the nature of them existing, that constitutes a security, just by the nature of the orange existing. You know, that's it. We don't forget the facts and circumstances surrounding the Howie case. It's just the nature of the orange. That's what was argued there, right? Of course not, obviously. But that's what they're arguing with XRP. XRP, by the nature of it existing, Could not be more clear that it's a freaking security. This don't make no damn sense as far as Moon Lambo's concerned. So that's it. Let me know what y'all think below. I always love hearing from you, but I think it is stupid. STOOPID, stupid. I'm not a financial advisor of any kind. I'm not offering legal or financial advice, just as a reminder. So you should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.